Ladies and gentlemen, welcome back to the ND Zone. My name is Kathy. I wanted to spend a little bit of time today debunking a myth that seems to be going around that Mr. Kohberger was granted a Franks hearing and that testimony was provided on the 23rd of January at a Franks hearing. And in reviewing some content that's been floating out there on the internet, it appears that certain statements that Judge Hippler said during open session, some people have taken to mean that the closed session immediately preceding that open session was a Franks hearing. I am here to provide you with conclusive evidence from Judge Hippler himself that Mr. Kohberger has not yet been granted a Franks hearing as of today. And I've looked at the docket. It's February 5th, 2025. It's still relatively early in the day in Ada County. There's a possibility that there might be a ruling in Mr. Kohberger's favor, granting a Franks hearing that might come down today or tomorrow possibly. But in terms of the 21st being a Franks hearing, that is absolutely false. It is a misrepresentation, and I'm going to show you exactly where you can go in the record, Idaho v. Kohberger, to read it for yourself directly from Judge Stephen J. Hippler. To go to the Idaho versus Kohberger docket, please follow this link. You're going to be directed to a site called the Idaho Cases of Judicial Interest. At one time early in the proceeding and at certain other times thereafter, Mr. Kohberger's was the first case that you would come to. Lately, however, you've had to scroll down past other cases before you get to Idaho versus Kohberger, and it has become, after well over 2 years of this proceeding going forward, very, very lengthy. So go to where you see Idaho versus Kohberger. You need to go down to January 22nd, 2025 on the docket and read an order regarding preservation of IGG evidence. This states, as discussed with the parties at the January 21st, 2025 status conference, that was a closed status conference, ladies and gentlemen, there is a significant evidentiary overlap between defendant's motion to suppress regarding genetic information and defendant's motion for a Franks hearing, insofar as it pertains to his proffer regarding law enforcement's use of investigative genetic genealogy, in parentheses, quote, IGG, evidentiary overlap. What does this mean? And the court has used the term significant evidentiary overlap. Well, this means that the same evidence that Mr. Kohberger proffered in his motion to suppress evidence regarding genetic information, the IgG DNA evidence that's been so hotly contested, one of the 14 such motions to suppress Mr. Kohberger filed November 14th, 2024, that you can read on the docket, and his motion for a Franks hearing. There's an overlap. There's evidence that was proffered for both of those motions. They are very different legal standards. They're very, very different motions. The Franks hearing is going to be extremely difficult for Mr. Kohberger to ever get. This is because of the legal standard. It challenges the warrant affidavit, not evidence collected, but it asserts that there is a falsehood or a recklessly indifferent regard for the truth that is so high that it's almost to the level of a falsehood. That's a negligence and a high negligence standard. The party is pointing to in the affidavit for the warrant affidavit, and that even if you were to take that statement away, there would be no other way to get probable cause. Looking at it the other way around, there could be 5 of these statements that are false. There could be 10 statements that are false to get to a ridiculous number. If there's an 11th statement standing on its own, that standing on its own could lead a magistrate to find probable cause, that defense motion for a Franks hearing under the law will be denied. To learn more about this legal standard, I very strongly recommend that you read the Jerome Franks versus State of Delaware, United States Supreme Court case. This is brought under a Fourth Amendment theory that this warrant affidavit that's challenged violated an individual's Fourth Amendment privileges. Now, a motion to suppress also alleges a violation of Fourth Amendment privileges, but as to the evidence that is garnered after a legal affidavit and warrant affidavit is issued. Example being, classic example, law enforcement goes to the magistrate and receives a warrant to go into a person's home and search a specific area of that home. Let's just say a basement, a corner closet in the basement where some sort of contraband that the law enforcement officials are looking for, a weapon used in a crime, clothing from a crime, other evidence of a crime. The magistrate says, yes, you can go into that closet. And let's just say there's a door from outside that leads directly to that closet, so you don't have to go through the entire house to get to it. If law enforcement, however, goes through the entire house and ransacks it, goes through every drawer, every closet, looks under beds, in the kitchen, the private areas, bedrooms, that might be grounds to get any evidence that's garnered suppressed, because the warrant only allowed them to go into one specific and limited area of the home. There are some exceptions, but just with no exceptions applied here in this example, that would be one. This order goes on to say, although the hearing set for January 23rd, 2025 is not intended as a Franks hearing in the interest of time and efficiency, the court will permit the parties to present their evidence on the IGG issue as if it were a Franks hearing. So we see what the court's saying here. Under no circumstances should this be construed as being an actual Franks hearing. He's allowing the parties, remember, it's not just Mr. Kohberger who brings the motion, but it's going to be also the State of Idaho who's opposing that motion. Both sides can present their evidence for time and efficiency purposes. This is what the court has ruled here. Goes on. By permitting such evidence, this is the overlapping evidence for the both motions, the court is not concluding or even implying, not even putting it out there that could be implied in any way, that this is a Franks hearing. That the court is not concluding or implying the defendant has satisfied the preliminary showings required by Franks, that's Franks versus Delaware, that's the test, on the IGG issue, nor is the court bound to consider the full extent of the evidence if it is ultimately concluded that defendant's proffer insufficient to warrant a Franks hearing on the matter. This is simply intended as a time and resource-saving measure. It is so ordered, dated this 22nd day of January, 2025, Stephen J. Hippler, District Judge. So there we have it, directly from the horse's mouth. There's so much misinformation that is floating around this case. And I believe, I'm giving my opinion, it's because a lot of people are not doing as you are, which is taking the time and the effort to actually read the filings, which you are all capable of doing and should do if you have an interest in this case. This will now conclude this episode of the Indie Zone. My name is Kathy. Thank you so much for joining us here today.